discuss with you something, some information about third-party placement scrutiny. So, in cases where, an H-1B worker is placed at a third-party site, how might the proposed regulations, okay, we have the question on screen as well, how might the proposed regulations increase scrutiny and RFEs? And how can employers, okay, firstly, like, let's take one by one. So if you can please answer this.
How might the proposed regulation increase scrutiny? As we just discussed, if they're asking for contracts and work orders, and if there's more than one party involved, in that chain of POs and work orders, they might ask for contracts and work orders between all the parties involved. Sometimes there's a vendor, there's a sub vendor, there's an end client, so there might be three or four parties, and getting contracts between all the parties may not be possible for the employer because they have no control over all the parties. They might be able to just get their contract between their vendor, the end client, but not the contracts between all the other parties. So that could lead to a denial of the H1. And also sometimes the duration of the PO may be only for a short period of time, and they might say that that doesn't show that they have specialty occupation work for the entire duration of the H1, so they could go back to saying that as well, and maybe they will then give H1s for a shorter period of time. They can scrutinize the contracts by calling the clients or calling the vendors to make sure that they have actually signed those contracts. And if they don't get the right person over on the phone, or if the person doesn't respond properly, they can cause issues that could cause issues for approval of the H1 as well.
Oh, okay. Okay. But then how can they, employers prepare to justify the specialty occupation status in third-party placement scenarios?
Specialty occupation is specialty. Yeah, I get what you're saying. So you're asking, so basically, if a specialty occupation, you decide whether it is a specialty occupation or not based on the job description.
Okay.
And so who gives the job description? The job description is usually given by the employer. But since the person is not working directly for the employer, but is actually working for an end client, they might want that job description to come from the end client directly.
Okay.
And if there's any discrepancy between what was filed in the as per the LCA and in the I-129 petition and in the description that the client is given, then they might deny the case, saying that, look, the job description given by the end client is different from the description given by the petitioner, or they might say that the job description given by the end client doesn't show that a bachelor's degree in a specific field is required, and they might deny it based on that.
Okay. Okay. Got it. So thank you so much for answering the question, Attorney Prashant.